We start with new information about the Safety Act. Over the last couple of weeks, several states' attorneys around Illinois have said the new legislation has major issues with the law. Several counties in Illinois have filed lawsuits stating the new legislation is unconstitutional. 3 counties that got the ball rolling were McHenry, Kankakee, and Will counties. Since then, many more have done the same around the state, including from our area. Take a look at this map. So far this week, Ogle and Joe Davis issued lawsuits, and as of today, Winnebago, Stevenson, and Boone counties now have all joined the mix. Winnebago County announced its complaint at a press conference today. 13 WREX's Manny Estopinan has all the details on what the state's attorney's office had to say. Manny.
Derek, in my hand, I have the 33-page complaint made public today, nearly identical to the other lawsuits made in other counties. This document outlines why State Attorney Jay Hanley thinks this law goes against the Illinois state constitution.
And filed suit on behalf of my office, Sheriff Caruana, and the people of the state of Illinois to challenge the constitutionality of the pretrial fairness portions of the Safety Act.
The Winnebago County State Attorney's Office sending a clear message to lawmakers. This law needs to be scrapped.
It will create unjust results, and it does not protect the public.
The lawsuit challenges the Safety Act on the following legal basis. The law is too broad and does not focus on one single topic. The law violates rights given to defendants and victims outlined in the Illinois Constitution. The law strips judges and courts of their power and decision-making. And the law is unconstitutionally vague. But faith leaders with the Rockford Urban Ministries says the law aims to make a more fair system.
But a lot of the folks who are there are only there because they can't pay their bond. And that's not fair. That's not just. It shouldn't be one system of justice for the rich and a different system of justice for the poor. And everybody knows that's broken. And fixing it is complicated. And big change is hard.
Reverend Johnson believes this can provide real change in people's lives.
When people are incarcerated awaiting trial, their chances of sort of being rehabilitated, if you will, of getting their life back on track is really seriously diminished. They lose their jobs, they lose their housing, which means they're more likely to commit a crime later.
Despite the lawsuit, the attorney's office does not wish to go back to the old system.
I am not a proponent for the return to the cash bail system. What I am a proponent of are models like New Jersey, and specifically New Jersey. And why the New Jersey model is one that I'm advocating for is because it allows any charge or someone charged with any offense to be detained.
The attorney's office hopes the court will find the safety unconstitutional and stop it from becoming effective January 1st.